requirement that was effective in October 2021 law. This town hall, as I said, is an outreach to our notaries and those who are interested. Time is reserved at the end of the presentation for questions and answers. In the meantime, if you have a question, you're welcome to put it in the chat box. But in order to prevent confusion about the source of the response, please do not, let me repeat that, please do not answer questions placed in the chat box. Our Secretary of State staff will announce the question in the chat box at the end of the town hall. We'll answer it then. Some of our staff may provide a link or some other information in the chat box, but it can become very confusing if notaries or others attempt to respond to questions there. So for those reasons, please do not. Notary offices are available at the SOS, the Office of the Secretary of State, to answer questions and to provide information only, but cannot provide legal advice. For legal advice, please contact legal counsel who specialize in the particular area of law about which you have a question or concern. We'll try to answer all of your questions, and of course, we'll invite questions during the Q&A session at the end. As we begin, please mute your microphone. You may keep your camera on if you like. And let me ask Deputy Secretary of State Luis Borda, are you on the call? I can't quite tell. We have so many people who are on right now. I know he wanted to welcome you. So, Mr. Secretary, if you're happy to invite you to say a few words. Very technical. But again, on behalf of our Secretary, Secretary John Wilbur, Deputy Secretary Luis Borda, I am thrilled that you're with us today. I hope this is really informative. And so, without further ado, please allow me to introduce your fabulous Division Administrator, Michael Schlein. Mike?
Thanks, Kathy. Welcome, everybody, today. So we're going to talk about a topic that seems to pique most people's interest, right? How to avoid complaints, top 10 mistakes that notaries make when notarizing documents.
Excuse me for 1 minute, Mike. Mike, if you can adjust your volume, make it a little louder, I think it might be easier for everyone to hear, please. Thank you.
Is that better, Kathy?
A little better.
All right. Now?
It's better yet. But if it can adjust upward still.
How about now?
Perfect. Thanks so much.
Yeah, so top 10 mistakes, different things notaries do, get themselves in some trouble. You know, obviously as notaries, we're here today, right? We want to learn and do the right thing. And we're not going to cover every aspect of notary law, but we are going to focus on this particular town hall on different things people do that are incorrect in hopes that if you're doing it a certain way and it's wrong, you know, you'll take from today, okay, this is what I need to do. So we'll just get, we're going to dive right in here. First list of 10, just commissioning errors. And these things seem super simple, but can cause headaches for you when you're trying to become a notary. When you become a notary, every time you renew, you have to go to the clerk of the circuit court to get sworn in and pick up that new commission. The first thing folks do, you know, and make a mistake on as a notary is just get to the courthouse within that 30 days of picking up that commission. If you don't do that, that commission gets revoked. You've got to start over again and reapply. You know, law says that a notary has 30 days to go to the clerk of the circuit court, get sworn in. We send that notification. It goes to your email at the email address you provided on your application. Knock on that inbox, check that spam folder, make sure you don't miss that notice, and then make sure you don't forget to go down there and get it within the next 30 days. We don't enjoy when you miss it. You don't enjoy when you miss it. Nobody enjoys when you don't get there in 30 days and get sworn in. But if that happens, you have to reapply. We prefer you not have to reapply either. So get down there within 30 days. Asking someone to pick up the commission on behalf of the notary. This is another no-no. We're going to get into this later on. Seals that you individually are the notary, only you are the notary. And you need to go get your commission, just you need to be the one using your notary seal. I'm hearing, getting a word that sound is muffled here. Hang on a second. Let me see if I can choose to a different camera. Sorry, guys. Screen here. Did I kick myself out?
Yeah, but your volume is much better now, Mike.
Okay.
I know it's body, so I think.
All right. Everybody can still see and hear me then? All right, good. Switch to the old technology. Shouldn't work better. So mistake number 2, failing to identify a signer.
Mike, I'm sorry for interrupting you. Would you go back because it was hard to hear? I know some folks said it was hard to hear. Thanks so much.
Yep. So mistake number 1, commissioning errors. Get to the courthouse within 30 days. Get sworn in within 30 days of the issuance of that commission. We send you an email notification when you're approved, whether it's a new applicant or a renewal applicant. Every time you're a notary, you become a notary, whether you're a new applicant or renewal applicant, you have to go to the courthouse, you have to get sworn in, and you have to do that within 30 days of the issuance of that notary commission. So make sure we get down there, and we get down there in a timely manner. Asking someone else to pick up the commission on behalf of the notary. This is another issue that we run into here sometimes, and you have to get it yourself. You individually are the notary. Only you can go get your commission, and nobody else can go get it for you. We're going to cover aspects similar to this with regards to using your notary seal later, and another mistake that notaries make. Only you can get your commission. Only you can use your commission. It's in your name, not anybody else's.
So Mike, this has been a real problem over the years, I know, and that is that often somebody would say, I don't have time, I'm going to send my secretary down to pick up the commission. The secretary appears at the clerk's office, and of course what they learn is that they're denied the opportunity to pick up the commission. This is a public office, folks, and that's why the notaries themselves are the ones who need to be sworn in. Pick up the commission yourself. Cannot be delegated to anyone else. Thanks for making that point, Mike.
Yeah, now hang on one sec. Now my video feed went out, so of course that would happen. All right. Still out?
It is still out.
Goodness gracious. All right. Better? I can't win today.
Yes, you're back on now. Thank you.
All right. Thanks for hanging in there, folks.
Yeah.
Done this many times, never had this issue. Technology is great when it works, right, boss? So mistake number 2, failure to identify the signer. This seems like such a simple thing. There are a few things being a notary you have to do every time somebody comes to you to get something notarized. And this is one of those things. Every time you notarize, you have to identify the person for whom you're notarizing. Every time without fail. There are different ways to identify folks, but the notary must always satisfactorily identify that person requesting the notarial act. Every time. I'm repeating myself, but I'm doing that on purpose to drive home the point. Every time. Different ways you can identify somebody. We have the most common way, right, is government issued identification. Passport, driver's license, consular ID, government issued non-driver ID card. A form of government ID that has the individual's photo and has their signature on it. So government issued ID that has their photo and their signature. That's a satisfactory form of government issued ID. Folks, sometimes, well, my photo's on my credit card. Well, it's not government issued. Or I have a state ID because I'm a state employee. It has my photo on it, but it does not have my signature. Therefore, it is not a valid form of ID. The law requires it to be government issued and contain your photo, the individual's photo and their signature. Another way of identifying a signer is through personal knowledge. And this is a way, we talk about, everybody's, do I really have to identify, they're my best friend. I've known them for a long time, or they're my boss. I know them. I work with them every day. I see them. I know who they. Personal knowledge is a way of identifying a signer. And what's personal knowledge? You have personal knowledge of the identity of the individual, personally appearing before the notary, that the individual is personally known to the notary through sufficient dealing to provide reasonable certainty that the individual has the identity claim. This is not somebody that you know in passing, or that comes in and out of your place of business every now and then, and you don't really know them that well. You just know them as a customer, but not that well. Personal knowledge of the identity of the individual. You know them. You don't just know about them or know who they are, generally speaking. You know them. And the last form is credible witness. And this is a means that can be used, say the individual requesting the act maybe doesn't have an ID, but they're with somebody who does, and you can identify that individual who is a credible witness, can identify the individual, the signer. It's best if the notary knows that credible witness, because then there's a chain of knowledge there, but that doesn't necessarily have to be the case. But credible witness, so we're identifying a witness who can identify the signer. There are instances where this is a perfectly reasonable or even normal usage, especially if we're talking about you're identifying minors, right? If you're under 16, probably don't have a government issued photo ID. Maybe they have a passport, but maybe not. And maybe mom or dad would have to identify them as a credible witness, because most minors don't have IDs. And sometimes folks, on the other end of the spectrum with age, older folks that maybe don't drive anymore, right? They may have an expired ID, and that's okay. An expired ID is okay. But if they don't have that, then you could use a credible witness. And, one aspect to think about is, does it make sense, right? If somebody drives to you to get something notarized, they don't have their driver's license on them. They have other issues, right? They got bigger problems on their hand than that. They should have a photo ID with them if they're coming to you to get the Notarial Act, right? Especially if they're the one driving to you. But there are instances where maybe somebody doesn't have a photo ID, and it makes perfectly good sense. So credible witness, that's to be used on occasion when a situation calls for it. That probably shouldn't be your everyday mode of identifying. Government ID is the best way, and personal knowledge, the people personally. One thing I understand in the chat box right now, people are talking about expired ID. The law does not require the ID to be current. It can be an expired driver's license. But the notary has to be satisfied with that identification. So the notary could require an extra piece of information should the person have an expired ID if they're not satisfied with that, right? But an expired ID is an acceptable form. There's a lot of information in our handbook about identification, and I'd refer folks to check that out. And there's a link to the law on our website as well, with regards to, you can go to 18-101 and just kind of read through the whole notary law. But the identification portion, it has to be, again, government issued ID with with a photo and a signature. It does not necessarily have to be a current ID. It can be expired.
Or even a driver's license for that matter.
Driver's license, right? Yep. So driver's license that's expired, passport, something like that you can look at that government issued ID and look at that photo and look at me and go, okay, yep, this is you. This is you. Mistake number 3 here, we get overcharging errors. $4 per Notarial Act. That's it, right? The fee is charged for each signature that the notary notarizes. So you can charge $4. If Kathy and I appear before you and we both sign and you're notarizing both of our signatures, that's $4 plus $4. So $4 per signature that's being notarized. There are additional fees that a notary could charge in certain situations, such as if it's the same exact document being notarized multiple times, A notary could charge $1 for each extra document that's being notarized. The notary can demand $1 for making a photocopy if they're requested that they make a copy of the document that was notarized, $1 for that. The notary can travel to perform notarial acts, and they can charge a fee for travel. A lot of times folks refer to notaries that travel as mobile notaries. It's not a separate licensing category. It's not a thing that you're going to ever see defined in the law. It's just a term that folks use. It doesn't have a legal meaning or definition behind it, but it's generally referring to folks, notaries that travel for notarial acts. Whether one calls themselves a mobile notary or not and travels for a notarial act, the notary can only charge certain fees for travel. A notary can charge a fee not to exceed $5 plus mileage. $5 plus mileage at the IRS rate for business travel. So if I'm traveling to a notary, or I'm sorry, if a notary is traveling to me, said that backwards, if a notary is traveling to me, that notary can charge me $5 because they had to come see me, plus mileage, plus $4 per notarial act. So again, I'll repeat that. If the notary had to travel, they can charge $5 because they had to travel, plus the mileage that was traveled to perform the notarial act, plus $4 per notarial act.
Yeah, so Mike, that's the key thing, right? Is that it doesn't make a difference whether it's in person at a bank or in your home or at a nursing home or wherever, at a UPS store or some other location. The actual charge for the Notarial Act at this time is $4 per act, period. Other fees are above and beyond that, and Mike just talked about mileage, which is set to the IRS rate, or a travel fee not to exceed $5. But the Notarial Act does not change, that is $4. Now, I think we'll talk a little bit later about some regulations that are in play that if they are effective, they should be effective next month in the state. That are in response to a law that was just changed, that gives the Office of the Secretary of State the option to create regulations to increase that fee. But those fees have not yet gone up. So anybody who is charging more than $4 is operating outside of the law.
Yep, thanks, Kathy. So mistake number 4, we have notary journal errors. And we're going to have a couple of pages here that discuss the notary journal. It used to be called the Fair Register of Official Acts. If many of you are probably familiar with the fact that the law changed significantly on October 1st, 2020. And it included a lot of changes. And one of the big areas that changed was the requirements around notaries journaling, notaries' requirement to keep records. There was always a requirement that a notary keep a journal, formerly called the Fair Register of Official Acts. But the changes in the law better outlined what is required for every journal entry and for the journal themselves. So I can't emphasize this enough. A notary is required to keep a journal. A notary is required to record each and every notarial act that they perform in that journal. There are no exceptions. If you're thinking of asking the question, but I notarize for the same person regularly, journal each and every time. Each and every time. But I know them, they're my friend, journal each and every time. Each and every notarial act must be recorded in your journal. There are no exceptions, 0 exceptions to this in the law. So your journal must chronicle all notarial acts, each and every one of them. What do notaries do, right? Notaries go, oh, I know them, I don't need to record it, or they're my friend, I don't need to record it, or I'll record it later and then they forget. Those are all mistakes notaries make. Maybe not with bad intention, right? That's not what I'm saying, but you have to record each and every notarial act in your journal. You will want that journal because there will be a point in time where you may need that journal. You may need to go verify that you did something for somebody or did something properly for somebody. And you need to have that record That record is important, most importantly for you, the notary. It's your record of all your official acts as an officer of the state of Maryland, as a notary public. And that record is there to help and support you. So make sure you're keeping that journal requirement. It is required, and it is really there at the end of the day. It's your protection. It's for your benefit, not just ours.
And Mike, I might just add here, I think it's probably wise in keeping that journal to indicate, all the information that's obviously needed to be required, but also how much you charge, the $4 fee for the Notarial Act. If you travel, $5 for the travel fee. If you had mileage, what that mileage, and really stipulate each and every one of those fees separately, so that when and if there's a question later, you have a record of it that you can provide, so that it is your confirmation of the fees that you charge and why you charge, which fees you charge and how much.
Yeah. Yep. And we're going to go over each and every entry, and that's one of the things I'll reiterate when we get to that particular slide is detailing those fees. A couple other points of emphasis on journals. If you're doing traditional notarial acts, right? Somebody brings you a document on paper and you notarize it and you keep a journal. You can only have one journal for your traditional notarial acts. So one, they call it in the law tangible. So one journal for tangible records that are notarized by you. That it has to be a bound book with numbered pages. Those entries need to be made chronologically, right? If you do it at the time of the Notarial Act, which is required, it has to be done contemporaneously with the performance of the Notarial Act, then every journal entry should be in order, right? If you're doing it while you're doing it, you can't put one that's from 3 days from now in front of one from today because you're journaling contemporaneously with the act. So if you lose your journal, make sure you let us know. If it's lost or stolen, let us know so we are aware of it. Get a new journal, start maintaining that journal. You can't maintain multiple paper journals. Can't do it. Need to have one source for that, and that is that one journal. So different requirements about a journal. Again, made contemporaneously with the act. Every time you record an entry in your journal, it needs to be done at the time of the Notarial Act, not at a later point in time, not at a time of anyone's choosing, or, and again, it's not up to your discretion. It must be made. And failure to retain and secure that journal. Your journal has to be kept for 10 years after the last Notarial Act in that journal. 10 years. That is a requirement in the law. You need to keep that record. So you may only be commissioned for 4 years, but as a notary that was commissioned for those 4 years, you're required to keep that journal for 10 years. So make sure you keep it. You fill one up, you keep it. You start a new one, right? They said, well, that's a lot to keep. It's a book, right? Put it for safekeeping. Put it in a file cabinet. Put it in your desk at home. Put it in a safe place where you can access it later if you need it, and only you can access it later if you need it. So each journal entry shall contain certain information. We'll run through this list here. Date and time of the Notarial Act was performed. Description of the record, if there's any type of description of the record, and the type of notarial act you performed. Different types of notarial acts, we had a whole town hall and different types of allowed notarial acts. If anybody wants us to see that and hasn't seen it yet, they can go to the notary page on our website, sos.maryland.gov, and you can click on the notary link, or maybe one of our notary officers can drop the direct link to the notary homepage on our website. All the town halls are posted there after the fact. And if anybody wants to see any of the previous town halls, they can see those recordings. And this one will get posted there within a few days as well. Full name and address of each individual for whom the Notarial Act is performed. Full name and address. Best to get that off of their driver's license, right? Or something else, some other form of government issued ID that has that information. If the identity of the individual is based on personal knowledge, a statement to that effect. So something in your journal, if you identified somebody through personal knowledge, you need to record that in your journal that you identified them through personal knowledge. A few more things here. Now we talked about if it's personal knowledge. Now if the individual is based on satisfactory evidence, most likely using an identification credential, a brief description of the method of identification and the ID credential presented, if any, including the date of issuance and expiration of the credential. Again, it doesn't necessarily have to be a current ID, and the ID number of the ID credential. So in an example here, I'm a notary, you come to me, you show me your driver's license. I identify you, and it's satisfactory. That picture is you, and I'm satisfied with that identification. And I watch you sign the document, and I'm going to notarize it. I'm going to do my journal entry. Brief description of the identification could be just Maryland driver's license, right? Maryland driver's license. Issue date, expiration date, it's on that license, and the identification number of that license, so the driver's license ID number. And I always get it, not rhetorical question, don't answer, but think to yourself, do you really know your own driver's license number? I bet most of us could probably get about 4 to 7 in before we don't know, right? So a very good way of showing you, the notary, did the right thing should it ever come into question. If you have their driver's license number in your journal, obviously you identified them, right? Because why would you know their driver's license number? I bet they don't probably know their driver's license either. There's always a few that know their driver's license number, but the overwhelming majority of folks do not know their full, what's it, I think a letter and 12 digits driver's license number. So driving home that point of why not only is it required, but why it's so important and why it's so helpful to have it. Fee charged, if any, by the notary public, and if no fees charged, record that no fee was charged. Kathy had mentioned breaking down that fee. If you're recording the fee in your journal, because, I mean, obviously, if you don't charge one, you record that you didn't, but if you're charging a fee for a notarial act and you drove somewhere, make sure you break that fee down. Give the details on it. Don't just put 20 bucks in there when inevitably somebody might complain and say, I was overcharged. Well, if you travel to that notarial act and you charge them $20, maybe it'd be good to write, you know, $5 travel fee, $4 per act, $11 mileage, or whatever the amount was. And that way there's a detail in there, and there shouldn't be a question, right? If you record your stuff good and thorough, thoroughly, then you know, that prevents future issues from happening.
Yeah, Mike, and that point, even indicating the number of miles so that someone can later verify, okay, that times the IRS rate really adds up. Is again, it's for your protection. And to the question that's in the chat box, no, you do not need to charge a fee. Just that if a fee is charged, this is the maximum fee at this point is $4 per fee. And just a reminder to everybody, please, please, please do not respond to the questions placed in the chat box. Our notary officers will do that. That's important so that prevents any confusion about the source of information.
Thanks, Kathy. Yep, and that's an important point there. Good question. You do not have to charge somebody to notarize for them. The fee is up to $4, up to $5 for travel, and the IRS rate for mileage. You could try to charge somebody less. You could charge them nothing at all. These are fees that are cap, right? The maximum you can charge is $4 per notarial act. So it's entirely up to the notary. Many notaries, we know some of them don't charge. So indication whether the individual is subject to the Notarial Act appeared in the physical presence of the notary or by means of communication technology remotely. So I'm going to have a town hall in the future about remote notarial acts. That's the next one up. I'll say sometime in November. And we're going to talk more in detail about remote notarial acts. But in your journal, you need to let people, you need to record whether it's physical presence or remotely located individual that appeared before you. And we're not going to go into great detail.
If mileage is being charged, it is the rate indicated by the IRS, Internal Revenue Service. You can easily go on their website to determine that. And fingerprints are not required, just, seeing a question coming up about that. Fingerprints are not required to be part of the notary journal nor to be taken.
Correct. If somebody doesn't want their prints taken, don't take them. It's not a requirement that you take somebody's fingerprints to notarize for them, and it's not a requirement of the journal to have somebody's fingerprints. Journal may be created on a tangible medium. We talked about the tangible medium, right? The traditional journal paper book. Also be created in electronic format. We talked about tangible records, only one journal at a time when doing tangible records, permanent book, bound, register with numbered pages. So not loose leaf sheets of paper randomly thrown in there, right? Bound book, numbered pages. Electronic records, there are times, if you're a remote notary or you're notarizing electronic records, most of the time, not always, but much of the time remotely, if it's an electronic record, you can have one or more journals to chronicle those acts. They must also be in permanent, tamper-evident electronic format that complies with the requirements of the law, any regulations adopted by the Secretary of State. Why, if it's electronic, would you be able to do more than one journal? Well, if you're a remote notary, you probably already know the answer to this question, right? You may use more than one remote notary vendor's technology. And as part of that technology, it usually includes a journaling aspect that records your notarial acts electronically in your journal on that platform. So you may use more than one platform or one technology vendor to remotely notarize or notarize electronic records. And as a part of that, you may have a journal on those platforms. So you could have more than one electronic journal for electronic notarial acts. So a lot about journals there. That's on purpose. There's a lot of information about journals. Folks, it's one of the most common things notaries don't have. And every notary that doesn't have one, when there's an issue, they really wish they had one. It's not a big deal until you need it. And then it's a big deal because it can easily dismiss an issue that you may face or find yourself involved in, having notarized a document for somebody that maybe later there's problems with that document or problems with the individuals involved. That journal's great, protects you all the time if you're doing it right. So mistake number 5, notary stamping device errors. Talked earlier about getting sworn in. You have to do it yourself. So we're going to talk a little bit about the seal, a notary stamping device, otherwise known as a seal. So failure to maintain and secure the stamping device, allowing someone else to use it, incorrectly printing printed information on that device, big issues. Most importantly, make sure that the seal says what it has to say, and make sure you're the only one that ever uses it and the only one that can use it. So what's required on a stamping device? The name of the notary public as it appears on the notary's commission. Your seal needs to have your name as it appears on that commission. You got that commission when you were sworn in at the clerk of the circuit court to start your term as a notary. The name on your seal must match that name. The words notary public have to be on the seal. And the county, or if you're sworn in Baltimore City of Baltimore, need to be on that seal. So in a situation, maybe let's say I got sworn in Anne Arundel County Circuit Court, my seal would say Michael Schlein, Notary Public, Anne Arundel County. Those are the 3 items that absolutely must be on your notary seal in order to make it a valid notary seal. You can put your expiration date on there. That's fine. You can put state of Maryland on there. That's fine. Totally fine. But those 3 items are the 3 that must be on there. But again, cannot emphasize enough. It is your seal. It has your name on it, and it is yours and only yours. It is no one else's. If maybe you became a notary because you work somewhere and they wanted you to become a notary. If you leave that place, you take that seal with you. It is yours. It has your name on it. Don't leave it there. It's yours. If the device is lost or stolen, let us know. Report that to us so that we are aware that there is a lost or stolen seal floating around out there with your name on it, just in case it shows up on some documents later. I've heard a few horror stories over the years with a notary. They became a notary because of their job. They left that job. They left their notary seal there, and they left their journal there. 2-3 years later, after they've been gone, their name starts showing up on documents being notarized by that company for that company. Why? Because their seal was left there. They didn't take it with them. And they left on great terms even. Most of the time, they left on good terms. It wasn't even contentious. But if you leave that seal sitting around, it may find its way into someone else's hands, and your name ends up on that document. Not their name, your name ends up on that document. So when there's a problem, inevitably there's an issue. Who gets dragged into that problem? Take your notary seal with you. It is yours. It has your name on it, not anyone else's. I am Michael Schlein. I'm the notary. the Secretary of State isn't the notary on my notary seal. I'm the notary on my notary seal, not my employer.
Mike, this is such a great point, and this applies to so much that occurs with notaries, right? So it is the notary, you yourselves, who are actually commissioned. It is not your employer. So you take your seal, you only charge the $4. You know, if an employer wants you to charge more than that, Mike, what do you tell them in that situation?
Nope, can't do it. You know, a notary public is an officer of the state of Maryland. So when you're wearing your hat as a notary public, you are wearing it as an officer of the state of Maryland. If anybody has any issues, let us know. I realize the pressures that may go with that. You know, not a lack of understanding of that, but as a notary public, it's your name on that seal. It's your name that goes on that document as a notary. And if there's ever an issue with that notarial act and it comes back up, it's your name, right? That's what the people are going to remember because that's what's on that document.
And the complaint will be against the notary, not against the employer.
Right.
So this is for your protection.
Stamping device, a few more pieces of information that are important to know about the stamping device. It must be capable of being copied together with the record to which it is affixed or attached or logically associated. It can be an embosser that makes the raised paper marks on the paper. It can be the rubber ink stamp that makes the ink impression on the paper. Both are in general used throughout the state. They can be copied, raised paper. If you shade the paper around the seal a certain way, you can get that to appear on a copy. A device lost or stolen, let us know, let us know, let us know. And if a notary resigns or expires or their commission's revoked, disable the stamping device. If you're not going to notarize anymore, render it unusable. Having a bad day, take a hammer to it. Have some fun with it, right? I say that, you know, kind of joking around or just a little, but make it unusable, right? Make it so that it cannot fall into somebody else's hands. Mistake number 6, incorrect in-person notarization. So there's different types of notarial acts. We have a whole town hall on this, mentioned earlier. Yeah, if you haven't seen it, take a look at it. It's on our website. In-person notarizations require the person to appear in the physical presence of the notary, regardless of the act being performed, right? We talked about identifying a signer. In order to identify a signer, they have to be before you. They have to be in person in front of you, whether that's physically in person for your traditional notarization of a tangible record or appearing in person remotely through remote technology that's authorized for remote notarial acts. But there are different types of notarial acts that a notary can perform. You can take an acknowledgement, oath or affirmation, witness or attest to a signature. You can certify or attest copies of certain documents. There's something in the law about protest, which is very, 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 very rare. But these are your powers as a notary. Know them, follow them. This is all you can do as a notary. If somebody is asking you to do more than this, can't do it. Your powers as a notary rest right here. Types of notarial acts. This is what you can perform as a notary public. And this is what you're doing when you're notarizing documents. So don't stray from these powers as a notary. These are it. So a few requirements of performing for in-person notarial acts: be in the same physical presence as the person requesting the act. Right? Always have to be in the same presence of the signer. Identify the signer. Generally speaking, valid government issued photo ID, right? That's the best way of identifying. Even if you have personal knowledge, it never hurts to look at the ID and record the information, right? Witnessing the signing of the document. There are some times where it may just be that they attest to the fact that they signed the document. But again, knowing the types of notarial acts will help you understand which ones they are. And we're not going to go into all those in great detail here, but just know what you're doing as a notary, know what type of notarial act you're performing. Affix the seal and complete the certificate. And then enter the journal in enter the act in your journal. Enter who you notarized for and what you were doing. These 5, no matter what you're doing these 5 every time, regardless of the type of act. It's there's a couple other steps depending on the type of act that may vary. These are your big 5 every time you're doing this. And electronic notarizations, you may notarize for somebody electronically in person as well, right? It's just replacing an electronic notarization is replacing the paper with an electronic record, but everything else is the same on a general electronic notarial act. Still witnessing a signature, still identifying them, sign it, still going to notarize that record, but just electronically. Sometimes folks that do electronic notarizations refer to themselves as an e-notary. It's not a separate licensing category. It's not a thing you're going to find in the law. Just like mobile notaries, it's not a thing in the law. It's a term people use. Notarial acts within the state of Maryland. So what do we mean by that? So a notary in Maryland can perform notarial acts anywhere within the state of Maryland. I gave an example earlier. I'm commissioned in Anne Arundel County. I can notarize in Anne Arundel County. I can notarize anywhere else in the state of Maryland. I'm on vacation at Ocean City. I can notarize in Ocean City. I'm on vacation up at Deep Creek. I can notarize. I'm in Maryland still. Anywhere else in Maryland, you can notarize in Maryland. So if you're a Maryland notary, your powers extend to the borders of the state of Maryland. You must be in Maryland when you notarize that document. Physically present in Maryland. Cannot be out of state. If I'm on vacation in Florida, I can't use my Maryland notary seal because I'm not in Maryland. You're on commission as a Maryland notary. Your authority and jurisdiction begins and ends in the state of Maryland, nowhere else. So the notary must be physically present in Maryland to act as a notary public. You might be commissioned. You could be commissioned in another state, right? Maybe you notarize in Virginia, Maryland, and DC. But if you want to notarize while you're standing in DC, you need to go be a DC notary. If you want to notarize while you're standing in Virginia, you need to be a Virginia notary. And those are separate processes. You would apply separately with them. In order to get commission in another jurisdiction, you would work with them to make that happen, not us. But the point being, your Maryland seal is only good in Maryland. And
that's a good point, because we have so many folks who live near or at the borders, Delaware, Pennsylvania, West Virginia, Virginia, DC. And that's, I think, a common question that they ask. So thanks so much for clarifying that.
Yep, thanks. And a notary can notarize documents from or for another state. Doesn't matter where the document came from. Doesn't matter where the document's going to be used. As long as you're in Maryland when you notarize that notarial act, right? Maybe the person is from California. They're on vacation in Maryland. Something happens, they need something notarized in a pinch, they come to a Maryland notary. Not a problem with that, right? Even though they're going to go take that document maybe to be used when they're back home in California. Totally fine. You're here in Maryland at the time of the Notarial Act. They're in your physical presence or in front of you. You can notarize for them. Doesn't matter where the document's coming from or going to, as long as you're physically present in Maryland at the time of the Notarial Act. Again, we mentioned different types of notarial acts. It's broken out a little more on this slide, but acknowledgments, oaths, affirmation, witness attest signature, certifying copies, copies of electronic records, the tangible records, protests, different types of notarial acts that you are allowed to perform as a notary public in the state of Maryland. But again, all of these are happening while you're physically present in Maryland. Even for remote notarial acts, if you're an authorized remote notary, that signer might be appearing before you remotely from wherever they are, from anywhere really. But you, the notary, when notarizing remotely even, need to be located in Maryland. So conflicts of interest, another good point here. Many folks don't think of it, or you think it's no big deal. Notaries need to avoid certain conflicts of interest. In particular, if you're a party to it, or for family members, maybe you have a financial interest in the transaction, don't notarize it, stay away. There are certain things you absolutely cannot do. You cannot perform a notarial act for yourself, right? So you can't notarize your own signature. Definitely can't do that. Cannot notarize for your spouse. Can't do that. Cannot notarize your signature or your spouse's signature. Never, ever, ever. Can't notarize for something in which the notary or the spouse has a direct beneficial interest. Notarial act performed in violation of this provision is voidable. So don't notarize for yourself. Don't notarize your spouse's signature. Don't notarize anything in which you or your spouse have a direct beneficial interest. Can't do it, period. Notary should refrain from performing notarial acts. And notice I said should, not shall. Should refrain from notarial acts for any immediate family member, even if there's not a legal duty to refrain. So you must refrain if it's your spouse. You should really refrain if it's for anybody else in your family. Brother wants something notarized, sister, mother, kid, don't notarize for them. Send them to somebody that's not you. Stay away from notarizing for family members and matters in which the notary is personally involved, even if indirectly, where there's no beneficial interest. If you might be involved, just stay out of it. There are about 90,000 notaries in Maryland. Trust me, there's one by you. Go to your bank, attorney if you have an attorney, local mailing or shipping packaging stores often have them. So they're around. They are around. Go find a notary that's not related to the person requesting the notarial act. We don't have an actual percentage, but if I had to give a ballpark guess of how many complaints we get about notaries public that involve notarizing for family members or conflicts between family members, I bet you it's at least 50%. At least. Everything is good until it is not, right? Everything is great. Everything's going well. Everybody's getting along. You're notarizing for a family member, and the next thing you know, something happens in the family, and you have family members fighting over something. It's a terrible thing to see. It's a terrible thing to be a part of. And you may think that'll never happen to me, but I assure you it does. And everybody that was involved in that dispute says, I never thought it would be me, but it becomes them, right? So just stay away from notarizing for family members. There's not a requirement in the law to refrain from notarizing for family members other than your spouse, but it's in your best interest to send them somewhere else. There are a lot of notaries out there. And then exceeding statutory authority of the notary public, prohibited acts and practices. So we talked about what a notary can do, right? Certain acts that a notary is allowed to do under Maryland law. And then there are other things that notaries sometimes find themselves doing that they cannot do. And the law expressly forbids these things. A notary does not have the ability to assist a person in drafting legal records. Can't give legal advice or practice law unless you're a licensed attorney, right? If you're a licensed attorney, you might draft legal records, give legal advice and practice law under your law license, under your license as an attorney. But if you're just a notary and you're not a licensed attorney, you can't draft legal records, you cannot give legal advice, and you cannot practice law. Don't put yourself out there as being able to do that. A notary public can act as an immigration consultant or an expert in immigration matters. Right? Again, as a notary public, you are there to do the things that a notary does, those 6 things that we went over. Identifying that the 6 types of notarial acts, but you're always identifying a signer, they're in your physical presence, you're being asked to notarize some kind of record, maybe it requires a signature, maybe it's a copy of something, you're completing the certificate, you're making the entry in your journal, but you're not acting as just as a notary public, as an immigration consultant. Represent a person in a judicial or administrative proceeding, whether relating to immigration or citizenship or any of those other related matters, right? You're practicing law in that sense as well, right? A notary public that isn't licensed to do these other things can't do those things. And you can't receive compensation for any of those things either, right? You can't do them. You definitely can't take pay for it. A few other things a notary public can't do, right? They can't engage themselves in false or deceptive advertising. Cannot use the word notario or notario publico unless the notary is an attorney licensed to practice law in the state. And anybody that's advertising that they're a notary or representing that the notary may assist, persons in drafting records, give legal advice. I'm sorry. Any notary that's advertising or representing themselves as a notary must disclose that they cannot draft legal records or give advice or otherwise practice law.
And Mike, it's interesting because some states, like for example, Maine, a notary is authorized to perform wedding ceremonies. That's not the case in Maryland. So I would say if you're concerned about what the scope of authority is, check the law. It's very clear. check our website.
Right, and that's a good point, right? Notaries, you get your notary commission from the state of Maryland. Mentioned earlier, if you want to notarize in DC, you get one from DC, Virginia, and that's true from anywhere, right? Notaries are licensed at the state level, and there is a thing called a federal notary, but other than mentioning that exists, just not going to touch that one. But every state law is a little different, right? Kathy just gave a great example about Maine and something a notary has the ability to do there. So make sure you're familiar with Maryland notary law. Every now and then we'll get a question, you know, I was a notary so-and-so in a different place, different state, and I was allowed to do that there. Can I do it here? Well, maybe if our laws are the same in that area, maybe not, right? Familiarize yourself with Maryland notary law. Don't rely on what you could or couldn't do in another state at the time. If you're becoming a Maryland notary, know the law related to notaries in Maryland. Mistake number 10, failing to affix the notarial certificate. I would say that in addition to journaling, this is probably the other big one now. Why is this a big mistake? Because up until October 1st, 2020, we told you if there was no certificate, don't attach one. And you had something called notary as official witness, and you would, date, sign, seal, my commission expires, and not add the certificate wording. Well, as of October 1st, 2020, the law now requires that there's a notarial certificate for every notarial act. If there's not a certificate on the document, the certificate must be attached by the notary public. And again, had a whole town hall, types of notarial acts. We covered certificates in that town hall as well. Sample certificates, you can find them in the law, you can find them in the handbook. They're there. They're there to be used by the notaries. Copy them, use that wording. But a certificate is required on every notarial act. If you do not attach a certificate to it, it's not a complete notarial act. So you must attach a certificate if one does not already appear on that record being brought before you to notarize. If there's already a certificate there, great, right? You complete it just like you always did. But now, if there's not a certificate, one must be affixed. And that's why it's so important to know the different types of notarial acts. I mean, other than it's, you're a notary, you should know it, right? Because you're a notary, that's what you're supposed to know. But even more important now, because you have to know what's being requested of you and what certificate to attach. Right? Somebody comes to you and says, hey, I need you to notarize my signature. Well, all right, that's you're going to attach a certificate that talks about, somebody appearing before you and signing the document. Somebody comes to you and they need an acknowledgement or an oath or something, then there's a certificate, a sample certificate in the handbook and in the law that you could affix for one of those notarial acts. So knowing the request and then affixing the right certificate based on the request of the signer. So again, have the handbook. If you don't have the handbook, you can get the handbook. And if you don't have the handbook and you're trying to get the handbook, there's a link to the law on our website. And it'll take you right to the law, and you can scroll through the different sections of the law. And a couple of those sections deal with notarial certificates. And there are examples of those right there in the law. The ones in our handbook are the exact same ones in the law. We took them right out of the law. Does it have to be exactly that certificate that's in the law? No, it needs to be something substantially similar to it. But there are, the law explains what the requirements are in more detail. But got to have a notarial certificate for it to be a notarial act. If there's not one there, you didn't complete the notarial act. And this is a newer phenomenon because of the change in the law, October 1, 2020. Many folks, talking to notaries, trying to educate people, right? And that's part of what this is all about, is trying to help people understand what they're doing and think about it a little more sometimes than they already do. Just outreach to folks. And we've done a lot of education on the enforcement side regarding notarial certificates. It wasn't a malicious thing by the notary. They just didn't know. And the most common thing is, I've been a notary for 20 years. And they're doing it this way. Okay, right, but the law changed, right? So now we have to do it a new way. And, don't rely on that I've been a notary forever thing. Know that law and pay attention to the changes in the law. This is a big change. October 1, 2020 is when this changed. Big change compared to what you were doing before. So it's important to know it. And that's really why, you know, finish with this one, right? Mistake number 10, the biggest one, the one we see the most now is this. And it's, like I said, it's mostly just because it's a newer thing. It's only been a thing for 2 years, almost 2 years to the day, right? That this has been a thing. And before that, it wasn't. So make sure we're aware of this. And if you learn anything else today, make sure you're checking over that law and that handbook and rereading and rethinking and understanding. But these are the big 10 mistakes that folks make. A couple other things on certificates. Again, attaching certificates executed contemporaneously with the act, just like the journal. Signed by the notary, dated by the notary, the jurisdiction in which the act was performed. What does that mean? You'll notice on notarial certificates, they always start with state of blank, county of blank. And then maybe it's sworn and subscribed or acknowledged before me or signed before me. But as a Maryland notary, that first one should always be state of Maryland, because that's where you're at when you're notarizing. The county of should be the county in which you're notarizing. I gave an example earlier. I'm commissioned in Anne Arundel County. Maybe I'm on vacation down at the ocean, and I'm notarizing something because I take my notary seal with me everywhere. And I'm notarizing a document for somebody, and on that document, that certificate is going to start state of Maryland, county of Worcester, because I'm in Worcester County. I'm in Ocean City in Worcester County. Signed before me, blah, 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 blah. And then my seal is going to say that I'm Michael Schlein, Notary Public, Anne Arundel County, right? So that certificate, you're completing that certificate for what is true at that time of the Notarial Act. And I think that's an important thing to say, because when you talk to folks, a lot of them, you know, you see a good chunk of the crowd, they're kind of, their face changes a little bit when you say that, because they've been writing the county in which they're commissioned on there forever. Well, we already know the county in which you're commissioned, right? It's on your notary seal. What you want to write on the certificate is the location at which this notarial act is occurring, which in my example would be state of Maryland, Worcester County. So notarial certificates, make sure we're filling them out for what's true at the moment in time of the notarial act. Where are we? What day is it? Who is before me that I'm notarizing for? And then the certificate's going to have your expiration date in there. Every example in the law includes a line for the expiration date. A few other things about certificates. A notary public may not affix their signature to or logically associated with the certificate until the act has been performed. So you've identified them. You've watched them sign, or they've attested to the fact that they signed. Now you can complete the certificate. The notary public, she'll seal that, right? Affix your seal to the certificate, which is attached to the record. If an act is for an electronic record, affix that electronic seal or logically associated with that certificate. And the certificate should be associated with that electronic record. So again, just lots of things here, but notarial certificates, new phenomenon, important to know that, important to be aware of the requirements with certificates. If it's already there, great, you complete it, right? But if it's not there, now you need to know that you have to affix one. And that is, like I said, I get a lot of that. So now, good thing is now everybody that's here today or is going to watch this later, you kind of heard that, and now you'll know, okay, if you've been not attaching that certificate, now you know to do it.
Thank you so much, Mike, and thanks to everyone who joined us today. As I shared earlier, and as indicated in email notification that you received inviting you to today's town hall was recorded. A link to the recording will be available on the Secretary of State's website. And by choosing to join the town hall, you consented to the recording as a part of it. As stated in the content in the presentation and earlier today, the content presentation is provided for informational purposes only. It is not intended to be legal advice. So I know we have some questions, so